Welcome to Family History Mysteries, a podcast that tells the stories uncovered through family history research, the unexpected stories of everyday people. I am an avid family historian who has been compiling my family tree for over 15 years, with nearly 20,000 people recorded in my trees.
Episode 59, Harry Albatross of Dunedoo. I came across Harry in a newspaper article outlining how his wife was contesting his will. Harry left the proceeds of his will to his nieces and nephews and clearly stated his wife was to obtain none of the proceeds of the will. This got me intrigued as to why. Harry Albatross Patrick was born at sea off Liverpool on the family's voyage out to Australia on the 30th of April 1854. They sailed on the ship Albatross, hence Harry's unusual middle name. Harry was the youngest of 9 children born to Scottish parents, John Patrick and Mary Brown. John was a cotton hand loom weaver in Scotland prior to their emigration. Harry and his brother William owned 3 properties, Eversley, Dillalah and Bollars in the Dunedoo, New South Wales district. In 1889 they purchased 100 acres at Dunedoo. By 1890, nearly 50,000 acres of land were owned by them in the area of Mogong, New South Wales. In 1892, he held a lease at Dillalah and Marygowan, totalling 1,920 acres. His brother William died in 1912 and Harry continued farming at Dunedoo. Harry Albatross Patrick married Claudia Caroline Wisby, and it took place in Mudgee on Tuesday, 5th of November 1907. Claudia was born in April 1872 in Richmond, New South Wales, and her parents were William Wisby and Mary Cave Wilder. She was 35 when she married Harry, and he was 53, and neither had been married before. Claudia left Harry on the 22nd of March 1909, only 18 months into their marriage. And this led to the detailed articles about the separation and the divorce petition. So on the 18th of November 1909, an article titled "A Divorce Appeal, Liability for Alimony" in the Banco Court held in Sydney on Thursday before the Acting Chief Justice Sir George Simpson, Mr Justice Cohen and Mr Justice Pring, judgment was given dismissing the appeal of Henry Albatross Patrick against an order made by Mr Justice Sly, sitting in divorce, on a petition by Claudia Caroline Patrick, responded in the suit, for alimony pending. The judge had referred the matter to the registrar for inquiry into the means of the parties. The suit is one of H.A. Patrick for the restitution of conjugal rights, and the respondent in her answer has set up a plea of cruelty and asks for a judicial separation. In the interval before the hearing of the suit, the respondent applied for alimony, which matter was, as stated, referred to the registrar. And the point now raised was whether, when the husband is petitioning for restitution of conjugal rights, the wife can obtain alimony. The Acting Chief Justice pointed out that a party to a matrimonial cause in a petition for alimony was entitled to such alimony only according to the means of the respondent and the position of the petitioner. In this appeal, it was contended that Mr Justice Sly had no jurisdiction to deal with the matter at all. It had been argued that, in the answer to a suit for the restitution of conjugal rights, there was no authority in the respondent to countercharge cruelty and ask for a decree of judicial separation by means of cruelty. In Section 25 of the Divorce Act, it was relied upon for that prohibition, and in his opinion, this argument was unfounded. In the old courts in England, respondent in a suit for the restitution of conjugal rights could obtain alimony immediately the marriage was proved. The principle was by virtue of Sections 4 and 5 of the Divorce Act, followed in the New South Wales Court. It followed immediately that the marriage was proved, the respondent was entitled to alimony, and it was therefore apparent that the court had jurisdiction. Again, in a suit for the restitution of conjugal rights in the old courts in England, the respondent could countercharge cruelty, and in many cases this was done. Thus, the argument that there could be no such countercharge in New South Wales fell to the ground. He was of the opinion the judge had jurisdiction and that the appeal must be dismissed. They did concur, and the appeal was dismissed with costs. So basically what they were saying was that Claudia could not go back and do a countercharge as a result of Harry Albatross saying that he was declaring restitution of conjugal rights. Then 7 months later, in June 1910, Patrick divorce case. Husband and his wife's brothers, the search that failed. In the divorce court on Friday, before Mr Justice Gordon, Harry Albatross Patrick petitioned for the restoration of conjugal rights. The petitioner in his evidence said that he married the respondent on the 10th of November 1907 at Mudgee, according to the rites of the Methodist Church. His wife left him on the 22nd of March 1909. He followed in search and went to her brother's place. And Mr Hammond asked, "How did they meet you?" And Harry said, 3 brothers came out and presented 3 rifles at me. And he was asked, "They aimed them at you?" He said, "Yes. Each of them in front of me put a cartridge in his rifle and each of them presented a rifle at my body." "You did not see the respondent?" And he said, "I did not." The witness went on to state that he afterwards went to Mudgee and at the respondent's parents' homes asked for her but did not see her, and his wife did not return. Cross-examined, the petitioner said that his wife had been keeping house for her brother before he married her and was the organist of a church at Gamba. He had known her about 8 or 10 months before he married her. After they were married, they went to live on his station, Widgeree. She first left him on the 12th of June 1908. For some weeks before she left, she became rather excited and inclined to be quarrelsome. Before she left, he said to her that he had heard that she had illegitimate children before her marriage. Mr Hammond asked, "Did she tell you that was absolutely false?" And Harry said, "She did." "Did she tell you to tell her who told you?" And he said, "Yes, she did." "And did you refuse?" And he said, "I told her it would only make trouble with her relations and I would rather not tell her." The witness went on to say that he had not told other persons that his wife was a bad woman and had never called her a bad name. He had not told Mr Nelson Wisby that if his wife came back she would not leave the station alive. His wife was ill in January 1909 and he afterwards told her that a brother had told him that she had 3 illegitimate children and also that she'd kept a place of bad repute in Western Australia. The respondent denied all these things. He did not remember having asked that she should be examined. He had never charged his wife with behaving improperly with a commercial traveller who had visited the station. He had never told his wife in September 1908 that he would give her in charge for baby farming, false registrations and concealment of birth. Continuing, the witness said that he went on search of his wife in the following morning, and the defence asked, "And weren't you armed too?" And Harry responded with no. "Haven't you a revolver?" He said no. "Did you have one at that time?" And he said no. "Did you not have a scrap with one of the brothers?" And he emphatically responded with no, I did not. Continuing, the witness said that he had not told his housekeeper that he would get a divorce within 3 months. The housekeeper left when his wife left, and he had not offered to keep her if she gave evidence for him. He had appealed against an order for the maintenance of an illegitimate child, but had failed in the appeal. The counsel asked, "You have had a good deal of experience of law in the last 12 to 15 years, have you not?" And Harry responded with, "Oh, I don't know." "Have you not had about 10 lawsuits in the last 12 or 15 years? And Harry responded with no. "How many?" he was asked. And Harry said, "I don't recollect one at all." "Do you remember getting into trouble through charging the police with sheep stealing?" And Harry responded by saying there was no charge made against any policeman. The witness stated that he had not inserted an advertisement in a country paper offering a £100 reward for any person giving information that led to the conviction of anyone stealing sheep, and £200 if the person convicted were a policeman. This concluded the case for the petitioner. The respondent said that up until July 1906 she had always lived with her mother and father, except when she was visiting relations. She afterwards went to her brother's place and kept home for him, and while there she became engaged to the petitioner. She went on to say that there was absolutely no truth in the allegations made against her. Neither before or after marriage she'd had an illegitimate child. She told the petitioner there was no truth in the allegations. She was fearfully upset about it, for she had never had a stain on her character. The petitioner could rave at her and say that if she could only confess he would be a happy man. His conduct when raving would frighten her, and in fact she had a message sent to the police, to Constable White, through a servant, and the constable came out, but he refused to do anything as it was a family matter. He advised her to write to her mother. When the petitioner finally did tell her the names of the persons who he said had told him the stories, she said she did not believe it, that they would not possibly have said such things. She wrote to the persons he had named, and they wrote back denying having told her husband anything of the sort. She showed those letters to her husband, and he called them dishonourable persons and added with regard to one of the people that he would chop them up on the meat block. Another article at this time in relation to the divorce case, Afraid to Breathe, Marital Troubles at Midnight. In the divorce court on Friday morning before Justice Gordon, the hearing was continued of the suit in which Harry Albatross Patrick is petitioning for the restoration of conjugal rights, and the respondent being Claudia Caroline Patrick, formerly Wisby. The respondent raised an issue of cruelty and asked for judicial separation. The respondent proceeded with her evidence and said that one night the petitioner woke up in a terrible rage, pulled the clothes off her and put his face so close to her that she thought he was going to bite her, and swore at her. He said he would kick her to pieces. She was terrified of her life. He would not allow her to have the clothes over her for 2 hours, and she was cold and stiff from exposure. He had threatened to shoot her relations and told her he would not take her out because he would be ashamed to be seen with her. She left her husband in July last year. She was suffering from nervous prostration, and that if she returned to her husband and had to face certain accusations, it would be serious for her and in fact affect her mentally. Matilda Scott, wife of George Scott, a boundary rider, said she and her husband were in the employ of the petitioner in 1908. One Tuesday night she heard the petitioner rowing with the respondent. Nelson Wisby, a brother of the respondent, gave evidence of conversations he'd had with the petitioners regarding negotiations between the parties for an amicable separation without coming to court. John Gollan, who until a few months ago had a holding near the petitioner's property, said that on the day the respondent left her home in March last year, he saw Patrick putting a lock on one of the doors. Prior to her going away, Mrs. Patrick had spoken to him about her troubles in the presence of Mrs. O'Neill. The witness admitted that he had arranged with Mrs. Bell and her son to get Mrs. Patrick away. Patrick had confided to him everything about his married relations. On 1 or 2 occasions, Patrick had ordered him off the station. Mrs. Elizabeth Cave Pine, a sister of the respondent, deposed that she had never heard anything of an improper character against the respondent. Patrick Joseph White, a constable of police stationed at Coolah, stated that in June 1908, Mrs. Patrick made a complaint to him, which prompted him to go to the station to investigate. On arrival at the station, Mrs. Patrick qualified her previous complaint and appeared to be frightened of the petitioner. Edward Dean, a coach builder carrying on business at Mudgee, said he'd known the parties for many years. He admitted that on one occasion he was secreting Mrs. Patrick from her husband. His reason for doing so was on account of something he had heard. James Bell denied certain allegations of his relationship with the respondent. Johnson MacDonald Wason, a station hand in the employ of Patrick, said that as far as he could see, there was nothing between the petitioner and the respondent when they were living at the station in 1908. That was 2 or 3 months prior to June that year. He was away from the homestead in March 1909, and on his return, Mrs. Patrick was not there. The witness said that he had heard Patrick talking to people about his wife. He had heard him say with regard to Mrs. Patrick's going away that it was cruel on him for her to have done so. The petitioner said that his wife had accused him of being irreligious and ungodly, and that he answered that whatever else he was not a hypocrite. She said, "You accuse me of being a hypocrite," and he replied that he did not think that she was as good as she professed. The issue of cruelty was raised on behalf of the respondent, who asked for judicial separation. The petitioner continued his evidence in reply. He never noticed his wife crying or her spirits being low before January 1909. She was in splendid spirits. He never asked her what she would take to quit and never return. The incident deposed to by the respondent about his jumping out of the bed one night in January and March 1909, when she declared that he stood over her with his fists and teeth clenched, that he said he had never hit her yet, but was fast coming to it, and that she was standing in her bare feet and asking him to allow her to pass as she was cold, and that he called her offensive names. The incident never happened. Something else, however, did happen. The petitioner wrote down what that something was and proceeded to say that he did not in any way ill-treat his wife on that occasion, nor did he have any quarrel with her at all. He did not recollect speaking with Mrs. O'Neill about anything that happened that night. It was not true that he prevented the respondent from writing to her relatives or receiving letters from them, nor was it true that she was practically a prisoner. He denied the statement made by her that he used to wake up in the night and start abusing her. As a matter of fact, she used to abuse him for snoring. The petitioner said he had ordered the witness Golan off his place 20 times, told him not to come to the homestead again. He had never discussed his wife with Golan except when she left. That was the only occasion. 18 witnesses all up gave evidence, and the judge reserved his decision for the morning of July the 1st, 1910. And His Honour said that it was curious in many ways, much as there were many circumstances that appeared to him inexplicable. Cruelty, as he understood it, was either physical violence or insulting accusations, conduct or words, and in order to found a claim for substantiated relief on that ground, it must go further than to be a mere answer to an issue for restitution of conjugal rights, and must be in the opinion of the court, such as either cause injury to the health or physical well-being of the person alleging it, but there must be a reasonable apprehension that such would be the case if she returned to cohabitation. So that before he could give relief on the counter-petition, His Honour must be satisfied that there has been such conduct on the part of the husband as to cause injury to the wife's health or well-being. His Honour then reviewed the facts disclosed in the case, which he described as extraordinary. He dealt at considerable length on what the petitioner had said had been told him concerning the respondent's character, and remarked that he had conveyed the information he said he had received in such a way that led her to the conclusion that he believed it. That attitude of mind towards his wife was assumed almost all through, and it still existed. His Honour expressed the opinion that there was not a scintilla of truth in any one of the suggestions concerning the respondent's character. They were neither true nor was there any foundation for them. He believed that Mrs. Patrick had been a pure, good woman from her childhood up until the present time, and he also believed in the main that her conduct in that period was correct, that it was the young incident that started the diseased train of thought, that there was persistent persecution on his part towards her, and that it had been carried so far that she found it impossible to live with him. The only result with regard to the petition, therefore, would be that it must be dismissed. With regard to the wife's petition for judicial separation, His Honour thought that she was entitled to it and accordingly granted it. So Harry Patrick died at the age of 81 on the 12th of May 1935, and there was a detailed obituary on Harry in the Mudgee Guardian. Grand old man, the death of Mr. H.A. Patrick, a pioneer of pioneers. The death occurred on Sunday evening last of Mr. H.A. Patrick of Dunedoo. The deceased was born at sea while his parents were on their way to Australia from Scotland in 1854. Until he was 8 years of age, the late Mr. Patrick lived at Newcastle, where the family had settled with their relations, who became known throughout Australia and in later years as colliery proprietors on a large scale. The famous John Brown and the late Mr. Patrick were first cousins and greatly resembled each other in manner and appearance. The deceased came in the early 60s with his people to Diggalar, an area of country which in those days extended from the boundaries of the present town of Marygowan to the country held by the Rouse family near Golgong. It included the present site of the townships of Dunedoo and Leadville. On the death of his father, a portion of his property was disposed of, and the deceased retaining the homestead block where he continued to live until 1910, when he sold out his interests and came to the infant township of Dunedoo to live. He was a familiar figure in Dunedoo from then onwards, and until a month ago when he was stricken down and had to be taken to his bed. His end came suddenly on Sunday evening after he spent an hour talking with an old friend. Heart failure was the immediate cause of death. The late Mr. Patrick, whose unbounded faith in the future of Dunedoo never wavered, was one of the leading citizens from its earliest days, and he did much to promote its general welfare. The late Mr. Patrick was self-educated, yet he acquired a sound knowledge of common law and for upwards of 20 years presided over the courts at Leadville and Cobborah. For a long time he was the only local justice of the peace in these parts, and this led to the government giving him power of magistrate to facilitate the work of the courts in between the quarterly visits by the police magistrate. When local government was introduced, the late Mr. Patrick was the government appointee to the Cobborah Shire Council, and he served in this capacity for many years. His duties as a councillor were a constant drain on his time. It meant a 3 days journey in a buggy over 120 miles from Digala to Guri and back each month, the trip at that time occupying 3 days. Then, when Dunedoo began, he had to wage a fight in the council to obtain special grants for the clearing of the streets, the building of the roads to the newly established township, and 101 other matters. Amongst other works for which he was directly responsible was the construction of the Benai crossing over the Castlereagh River near Mendurin. This work was carried out to a small cost to the council, Mr. Patrick himself supervising the work. He refused the presidency of the Shire Council at the beginning of each term, holding to the opinion that it was necessary for a Guri man to hold the position because of the proximity to the office. He was, however, as a mark of respect, elected president for 1 day, his colleagues insisting, conferring this honour upon him. The deceased was right throughout his residency in Dunedoo, firmly of the belief that Dunedoo should have a public hospital. In 1921, he donated the land for this purpose, and a movement begun that resulted in the sum of over £800 being collected for this purpose. For various reasons, the project was dropped, but the old gentleman never faltered in his conviction that the money should be held for the original purpose, no matter when the hospital should become an accomplished fact. It has been said of the late Mr. Patrick that he was hard to get on with, and this trait in his character was but a legacy of his Scotch ancestors, who were dour and uncommunicative except to friends, who found much that was kindly and generous in his inflexible character. No worthy cause in charity's name ever asked his assistance in vain, and his gifts, ever on the generous side, were kept as secret as such acts could possibly be. There are many who could testify to his sterling worth in this direction. There are many also who will think kindly of him for the assistance given through the years where he lived and worked amongst us. The deceased retired 10 years ago and went to live in Wallaroo Street, Dunedoo. The late Mr. Patrick married late in life, and his wife survives him. She was a member of the Wisby family, one of the pioneering families of Leys Creek. When it was realised that the end was in sight, that his long and useful life was nearly past, his relations were notified. Many came from Newcastle, Gull and Gambone and Coonamble, and to them Mr. Patrick expressed a desire to be buried at Gambone, together with his mother and brothers. During the past 10 years, the deceased was looked after by Miss Tilly Glass, his faithful housekeeper, to whom the death of her old employer came as a sorrowful ordeal. So his mother Mary was the sister of James and Alexander Brown, who pioneered the Newcastle goldfields. In February 1936, in equity, widow's claim for maintenance, Mr. H.A. Patrick's will. The hearing was resumed of the application by Claudia Caroline Patrick for an order of maintenance under the Testator's Family Maintenance Act from the estate of her late husband, Harry Albatross Patrick, formerly of Dunedoo Grazier. Mr. Patrick, who died in May, aged 81, left an estate of £50,965, which he bequeathed to his nieces and nephews. His will contained a clause expressly directing that in no circumstances should any part of his estate pass to his wife. It appeared that the applicant, who was then 21 and the testator 53 when they married in 1907, 2 years after they married, Mr. Patrick sought restitution of conjugal rights, and this was dismissed, but a cross petition by the wife alleging cruelty, a decree that was made in her favour, and she was declared judicially separated from her husband. Mrs. Patrick then commenced proceedings for permanent alimony, but after they had proceeded a certain distance, a settlement was reached in terms filed in court. By this, Mrs. Patrick agreed to accept £1,500 in full satisfaction of her claim. Later, she executed a deed of release, absolutely releasing her husband, his heirs, executors and assigns from all manner of action, suit, claim and demand, which she might have at any time thereafter against him, Before going into the merits of the application, the court heard argument on a submission that having executed the deed of release, the applicant had disentitled herself to the benefits of the Testator's Family Maintenance Act. It was admitted that when the release was executed in 1911, neither of the parties contemplating contracting out of the Testator's Family Maintenance Act, as it wasn't passed until 1916. It was contended, however, for the beneficiaries represented that on the construction, the deed meant that Mrs. Patrick had abandoned all claims to which she might be entitled to as wife. His Honour held that on strict construction, the deed of release did not cover the present claim made by Mrs. Patrick. The court proceeded to the hearing of the application on its merits, and an order was made that Mrs. Patrick should be paid £4 a week during widowhood as from the date of the testator's death. So basically it meant that at the time of their divorce there was an agreement, there was a settlement made. Claudia was given £1,500 and that was to be the rest of her entitlement. She was not entitled to anything further. Harry in his will clearly stated that as well. However, in 1916, there was a Testator's Family Maintenance Act, so a new law that came into place. And as a result, she was entitled to an amount because she was still his widow. And so as a result, she could put a claim in, which she was successful at doing. And Claudia died in February 1949 in Sydney, aged 76. So she effectively had £4 a week for 13 years from Harry's funds. So that amounted to approximately £2,700 in total. By the sounds of it, I'm sure that Harry would not have been very happy about. So definitely what was described as a sensational case certainly had twists and turns, and it was clear that it was obviously not a happy marriage for both, unfortunately.
If you are interested in sharing your story on my podcast Family History Mysteries, please go to my Facebook page and send me a message. If you would like some assistance in filling in the gaps in your family tree to see what mysteries you solve, please get in touch. And don't forget you can have early access to episodes by subscribing, and you'll also gain access to bonus episodes